All right, Texas, we have another hemp law update, and this one comes with a very real deadline. Beginning July 31st, 2026, manufactured or concentrated Delta-8 THC and other THC isomers that are not Delta-9 will be treated as Schedule I controlled substances under the Texas Controlled Substances Schedule. Say that 5 times fast. That means Delta-8 gummies, tinctures, and other products will not remain legal after this deadline. And this is not just a retailer issue. Once a substance is placed under Schedule I, selling, manufacturing, distributing, or possessing it can create a lot of legal exposure. But, and this is a really big but, this does not mean every single THC product in Texas becomes illegal come July 31st. Compliant hemp-derived Delta-9 THC is not banned by any means. CBD, CBG, CBN, CBC, THCV, those are also not banned. There are also important gray areas involving trace cannabinoids, newer compounds, and certain extracts that we're going to talk about in this video. So throughout this video, I'm going to explain what changed, how we got here, what appears to be legal, what appears to be illegal, and where businesses and consumers like yourself actually can go for advice and don't rely just on the social media posts. Obviously, this is a YouTube. This is technically social media. We also share a lot of EDU posts on our Instagram. But when it comes to legal advice and what we share here, we do a lot of extensive research and we do a lot of planning ahead of these videos to make sure that we're giving you the most accurate and up-to-date information as possible. So while I would say we're obviously not the law here at Restart, we really try our best to educate ourselves. So we're giving you a very clear answer moving forward. Please know that this is not legal advice. This is for educational purposes only. And these rules are current as of July 20th, 2026. First, a major point that's getting lost online. The Texas legislature did not pass this new bill or new law banning Delta-8 entirely. And the governor didn't just sign a new Delta-8 bill. What happened was that the Department of State Health Services, DSHS, or DISHES as we like to call it here in Texas, reinstated language from a court case back in 2021 from the Texas Schedule of Controlled Substances after a multi-year court case ended. The agency published this reinstatement in the Texas Registrar on July 10th, 2026. And DISHES lists this date as effective as July 31st, 2026. So giving us 21 days to essentially sell out and be done with it. So this is an agency scheduling action coming back into effect after some litigation, not an entirely new vote at the Capitol. Here is the short timeline. In 2019, Texas passed House Bill 1325 and adopted a hemp definition based largely on Delta-9 THC concentration. Hemp included the plant, its derivatives, isomers, extracts, cannabinoids, and acids as long as the Delta-9 THC did not exceed the dry weight basis of 0.3%. That language created a market for consumable hemp products, including Delta-8 THC. Now, one of the biggest misconceptions about Delta-8 is that it's highly synthetic, and while you can find synthetic Delta-8 on the market, not all Delta-8 is synthetic. Delta-8 does exist naturally in the cannabis plant, but naturally in very, very, very small amounts. Most intoxicating Delta-8 products on the market right now are not simply made by extracting it from the plant in abundance, because again, that really small concentration, if you think about the products out there, it is very difficult to only extract Delta-8 from the plant and have it concentrated into an edible or a tincture or topical. Delta-8 is commonly produced by converting CBD into Delta-8. Because hemp-derived CBD is found much more naturally in the plant and in higher concentrations, a lot of chemists, scientists can take CBD and synthesize it and turn it into Delta-8. In 2021, the Department of State Health Services Commissioner modified the Controlled Substances Schedule and announced that Delta-8 in commercial concentrations was controlled. Hemp businesses sued. A Travis County judge issued a temporary injunction that blocked those those definitions while the case moved through the courts. That injunction is why Delta-8 products could legally be sold to Texans for years. On May 1st, 2026, so this year as this video is being recorded, the Supreme Court of Texas actually reversed that injunction. The court held that the commissioner had the authority to make the scheduling decision and reject the business's claims in this lawsuit. The court's mandate issued on June 5th, which ended the case. Dishes then republished the old definitions with an effective date of July 31st. The reinstated definition, though, is much broader than the term Delta-8. It covers tetrahydrocannabinols naturally occurring in cannabis, while creating an exception to up to 0.3% of Delta-9 THC. It also covers synthetic equivalents, synthetic substances, derivatives, and other isomers when they have a similar chemical structure and pharmacological activity to substances in the cannabis plant. The notice specifically says that naming conventions are not standardized and that compounds can still be covered regardless of their number, used to describe the atomic position. I know that's a little bit confusing, so in plain English, changing the number behind the delta is not a loophole. So think of Delta-10, Delta-8, Delta-6, HHC, THCP. Those are all things that are now going to be illegal come July 31st. Dishes also reinstated its definition of marijuana extract. The hemp extract definition is tied to Delta-9 THC, and the wording separately calls out separated resin, which matters for highly concentrated extract categories and is one of the reasons why businesses simply can't just rely on, oh, well, it's hemp-derived, therefore it's legal. So what will actually be illegal come July 31st? The clearest answer and simplest answer is manufactured or concentrated Delta-8 THC. If a gummy, tincture, disposable, concentrate, anything of the sorts is formulated and marketed to deliver a meaningful dose of Delta-8, the state's opinion is that it is now considered a Schedule I drug. This includes products also sold as Delta-10, Delta-6, THCP, and other derivatives. Those all fall under this same definition. The super old argument, which I would hope that most business owners understand by now, is that the argument that it just came from hemp doesn't mean that it's going to be fully legal or compliant anymore. Here at Restart, we did carry Delta-8 for a really long time, and we had a lot of customers who really enjoyed it and loved it because it was high quality, it was synthesized, not synthetic. It was something that was not as potent or as strong as Delta-9, and a lot of people really liked the effects of it compared to Delta-9. So while we were sourcing a really high quality product of Delta-8, unfortunately for those customers, we have since taken Delta-8 off our shelves in line with the current law and what we're going to be seeing here in Texas. Now, other things like HHC, THCP, Delta-10, those are things that we didn't ever carry because we didn't really understand how they would make you feel and what the long-term effects of those products were. I'm sure you could find good quality sources, but what we believe at Restart is anything that's stronger than Delta-9, probably proceed with caution. Delta-8 was something that was not as strong. Think of 8 is the number before 9. So just inherently wasn't as strong as Delta-9 THC. And Delta-9 is like your baseline, is your OG. So as a company, we chose not to carry other isomers like HHC, Delta-10, THCP, because again, we didn't know the long-term repercussions. And anything that we sell, we want to make sure that it's one, something that we're comfortable taking ourselves, and two, that we're comfortable selling to you guys, right? We have a responsibility as a company in a industry that sells drugs to make sure that the community, our customers, are consuming safe products. I think important carve out is, again, this is only talking about what is currently safe, which is Delta-9 THC. That 0.3% really talks about Delta-9. It's very specific in the Farm Bill. You can look at the 2018 Farm Bill, that is the carve out there. What this new ruling and scheduling is covering is all of the other isomers, all the other things that dishes or the state is a little bit scared about, and they want to make sure they cover it all so that nothing, scary happens, I guess. I personally think there was probably a better way to go about it, but also because there's that level of responsibility and there are a lot of companies out there who aren't selling responsibly, unfortunately kind of get why they're doing it. It doesn't make it right. It doesn't mean that I don't want to give you access to something, but when you just let the floodgates open and let any other cannabinoid without proper research or testing go into the market, it creates a really big problem for how it affects an individual. And that's just something that obviously led us to what we're seeing today with, scheduling these things as a Schedule 1 drug. Now we're going to talk about one of the most important nuances to this new scheduling. The Supreme Court opinion recognizes that a naturally occurring Delta-8 in the actual hemp plant was decontrolled by the 2019 statute. The opinion also says the commissioner represented that naturally occurring trace Delta-8 is tolerable under the current legal system. But the court does describe those amounts as exceedingly small and nearly impossible to detect. That's not a green light to deliver a product or sell a product that contains 10, 25, 50, 100 milligrams of Delta-8 THC per serving. It is a very narrow distinction that is meant to avoid turning ordinary compliant hemp products into contraband, simply because the plant may just naturally have Delta-8. So for instance, if you look at our Delta-9 products, our testing, sometimes you may see a non-detectable or a really small amount of Delta-8. That is because that extract that we're using has trace amounts of Delta-8. So the good carve out to this is that it doesn't just get rid of all of our products entirely. It's really for the concentrated forms of these products. On the flip side, Dishes hasn't provided a clear numerical value to what trace amounts actually equals. So a measurable amount of Delta-8 on a COA, consider reviewing it if you're a business owner selling these products, especially if you know that that product was converted Delta-8. So again, if you look at a COA, sometimes it'll say ND, non-detectable, sometimes it'll be a super, super small amount, less than 0.3%. I don't quite know exactly what they're looking for. Again, there's no numerical value, but if you're buying Delta-9 products from a company, this is like a good tip to look out for if you're a business owner. Ask for the COAs. Make sure if you're buying a Delta-9 product, that test is accurate and they're not supplementing Delta-8 into it and just calling it all THC. So what is still legal after this date? Again, Delta-9 THC is not affected by this schedule as long as the product remains within applicable Texas hemp limits and follows all of our other current laws. So child-proof packaging, selling to 21 plus, making sure you have your hemp retailer or manufacturer license. The familiar threshold, what we're all really should know, is at that 0.3% by dry weight limit. Any Delta-9 products of yours, and if you're working with a really good manufacturer, they're going to tell you what is they can do, like what is the limit if they can put in a gummy or a chocolate bar, what have you. So for example, we're currently working with a manufacturer and we want to produce a certain milligram gummy. Let's call it 10 milligrams, right? We want to produce a 10 milligram gummy. That gummy varies by size of what we can legally put in the product. We want to produce a 20 milligram gummy, a 40 milligram gummy. The more milligrams that gummy is, the bigger and more heavy that product has to be in order to stay compliant with the 0.3% by dry weight basis. Also, a side note, just so maybe the consumer understands what us business owners go through daily, weekly, yearly, being in the hemp industry here in Texas, not only are we trying to comply with the law of the 0.3 of Delta-9% on a dry weight, we also need to have full panel testing, which obviously is awesome to make sure that you're testing for pesticides, herbicides, heavy metals, all of those things. But those tests are pricey. They are very pricey. They can range anywhere from $200 up to, I've seen $500 for a single test on one product in one batch. There's also licensing fee increases. So on the manufacturing and the retailer side, labeling, packaging changes for some people. Maybe they don't have the proper child proofing, or maybe they have to switch their packaging entirely. Maybe their label is missing the "this contains THC" call out, or maybe it doesn't have, I don't know, this is not intended for children call out on it. Things that, again, we at Restart have always self-regulated, and we've always tried to follow the rules of legal state because they have rules set, right? So it's pretty easy to follow what other people are doing. That doesn't mean we do everything perfect. I think over the years, we've changed a lot in how we present our products and what we put on our labels, but it's still, we have room to grow. There's room to grow for everybody. And so right now, you go into our shop or you go online, all of our products are either in childproof packaging and sold as such, or it's a package that's put inside of a childproof packaging. So if you have it and you need to store it, it at least has that checked off the list for dishes. There's also age verification, obviously. So on our website, if you go shop, you reach towards the end, you'll notice in the beginning when you go to our site, it says verify that you're 21 plus. At the very end at checkout, you're also gonna have to verify with your ID that you are who you say you are and that you're 21 years or older in order to actually check out and complete that process. And one of the biggest changes and something that we really need to get our shit together when all this ruling started to change here in Texas was record keeping. They are asking us to keep many records, not just digitally, but printouts for our retail stores. Again, we love compliance. I wanna make sure that we're following the rules. I wanna make sure that Dishes has what it needs, but it's just a lot of change at once. So if you notice that a business like Restart or a small business anywhere you buy from is maybe changing their product offerings or they're out of stock of something, just know we're working very hard to stay compliant with all these new rule changes. If you have questions, obviously reach out to us, reach out to our team. But in the end, we wanna make sure that we're selling compliant products. We wanna stay in the business. We wanna make sure that you have access to our products. And to do all those things, we have to comply with all these rules, crazy or not. At any time. Back to what's legal or illegal, CBD, CBG, CBN, all those other cannabinoids are also not banned by this particular scheduling. That doesn't make every one of those non-THC products compliant, but it does mean that as long as they're not containing Delta-8, Delta-10, those products are still compliant and legal to sell and have as a consumer. So for you as a consumer, if you are purchasing from your favorite companies in Texas, that means you're still gonna see a lot of Delta-9 on the shelves. You'll see CBD, CBG, what else is there? CBN, THCV, CBC that we just added to our menu. None of those are disappearing come July 31st. The market is definitely gonna switch away from commercial Delta-8 products and probably gear more towards Delta-9 so that we stay current, compliant, and stay in business. So what about THCA, HHC, THCP, THCO, and every other THC, whatever elemental P under the sun? This is where I wanna take a minute to slow down. I know I've mentioned it kind of throughout the video, so this might be me repeating myself, but I feel like it's really important to go a little bit deeper into what all this means for those specific cannabinoids. And it's not just like a simple yes or no list that I can give you either based on these rules. The biggest one and the one that's probably the most popular after Delta-9 as a THC is THCA. THCA is not mentioned in this notice, but THCA products are affected by a separate ruling involving total Delta-9 THC calculations. So before we were following the federal rule, which was calculating Delta-9 THC by 0.3 dry weight basis, now in Texas, we are under a total THC calculation. I use air quotes because obviously this calculation does include all the THCs, but really focuses on Delta-9 and THCA. There is a very specific calculation, but essentially what was a 0.3 of just calculating Delta-9, now we're including THCA, and that is why THCA is affected. But again, that's a completely separate rule than what's happening here with Delta-8 and these isomers. That separate rule fight has also been in court. So don't use this video as, oh, well, she didn't mention THCA, therefore THCA is compliant. No, unfortunately, that means that this video is really covering a specific Schedule 1 drug ruling. THCA is a whole different conversation. That being said, products marketed as THCP, THCO do require even more caution. Some are not technically THC isomers in like the narrow chemistry sense, but the language also uses broader words such as synthetic equivalents or derivatives with similar chemical structure and pharmacological activity. And for resin, hash, rosin, other forms of concentrate like that, the reinstated marijuana extract wording adds yet another layer of uncertainty. And this is an area where a retailer should make a guess based on the Delta-9 number printed out in front of them. You really have to consider, is it worth it? Is it worth closing down the business or getting products confiscated based on the interpretation of this new scheduling? So if you're a consumer, the most practical advice is try not to treat July 31st as a stockpile of Delta-8 or its isomers or derivatives. Unfortunately, the deadline affects the retailer or the manufacturer selling the product, but it also affects you as the consumer possessing the product, because possession of these kinds of products after July 31st do carry some legal risk as well. And if you use Delta-8 specifically for sleep, discomfort, stress, or another personal reason, talk to a qualified healthcare professional about some alternatives. Or honestly, you can come talk to Restart. While we're not, qualified healthcare professionals, we have over 8 years of experience helping customers find solutions for those things. We know these changes aren't abstract for many Texans. People have built routines and livelihoods around these kinds of products, and losing access to these things can feel really personal and disruptive to your daily life. As for hemp business owners, this isn't just a simple label edit problem. This isn't just like a slap a different label on it and call it a day. It is a inventory, purchasing, formulation, testing, and compliance problem. So it's a lot. You need to go through all of your SKUs, audit every single one of them, audit every single one of your COAs. I know it sounds really cumbersome and it's really tiring. And I know it because we freaking did it, okay? We spent so much time when this all was happening in getting all of our ducks in a row and getting our shit together that I lost a lot of sleep. Our team lost a lot of sleep. But in the end, it is very worth it. And honestly, we came out with an even better system on the back end that we actually use now for tracking, ordering. And although it was very stressful at the time and very annoying at the time, and we were under a really hard deadline at the time, now that we have things in place, it honestly helps our business run that much better. So if you're a business who carries not just Delta-8, but Delta-10, Delta-6, look at your COAs and make sure that you're not carrying these products or selling these products after July 31st. You can flag products with issues. Maybe your manufacturer sold you something that wasn't what you thought it was, and make sure to have those conversations with your manufacturers or find other manufacturers that are compliant, because I promise you, there are a lot of manufacturers out there doing things correctly. So if you're working with some that are not, find somebody else. If you have any specific legal questions, obviously consult with legal counsel, go find a lawyer. Maybe you have a lawyer in your company. Definitely go talk to a lawyer if you have any sort of questions like that. And although there are really great manufacturers and suppliers, I wouldn't just rely solely on them for all the advice. That is what these lawyers come into play for. And if you get into a pickle, who's gonna fight for you in the end? Is it your manufacturer or is it your lawyer? Probably your lawyer. Also, remember that Dishes can use its civil authority against licensed and registered businesses, while criminal enforcement can come through law enforcement agencies and prosecutors. At Restart, it means that we would rather be upfront and transparent about a product change or a catalog change than pretend that the deadline isn't real. So like I said, we already went through this entire process, thankfully, so we're not having to go through it again or right now. But it was a lot. If you're a business owner out there, I feel for you. It sucks. We're a really small team. We have less than 20 people that work for us. We run an e-commerce. We run 2 physical locations, our 2 dispensaries, and it's a lot to keep up with for our team because we're business owners, right? We wear a lot of hats, as they like to say. That being said, I would say compliance is one of the most important things, not just because it's what Dishes is saying, but you have a responsibility to your customers to make sure that you're selling them products that they're not going to get in trouble with and they're not going to be harmed by. So to close out the video, I know this was a long one, but here's the bottom line. Beginning July 31st, 2026, commercial Delta-8 and other non-Delta-9 THC isomers are being treated as Schedule 1 controlled substances here in Texas. The fact that a product started as hemp-derived CBD doesn't cut anymore. Now, naturally occurring trace amounts of Delta-8 are totally fine, but if it was converted or concentrated, those are a no-go. Compliant hemp-derived Delta-9 products, CBD, CBG, CBN, CBC, those are not banned and not being touched by this specific notice. But remember, every other product you sell still has to comply with other Texas laws and other rules proposed by Dishes. I don't know if you've noticed, but this industry changes rapidly. And another lawsuit, court order, agency update, new law could change the answer again. So make sure to check the date of this video if you're seeing this well into the future, and verify the current rules in your state before you buy, sell, or travel with product. If you found this breakdown helpful, Thank you so much for watching, and I genuinely hope you did find it helpful. You can support Restart, support our channel by subscribing to the channel, liking this video, and sharing it either with your fellow cannabis consumer friends or fellow hemp business owners in the state. We will keep doing our best to translate Texas hemp policy as the rules change and develop. We're approaching November, and that is a really big conversation that we'll make even more videos about. But for now, if you found it helpful, leave a comment below, ask questions below, and we hope to see you in the next video. Bye.